Today's webinar is presented in partnership with the National Health Law Program. And during the webinar, Mara Youdelman, Managing Attorney at the National Health Law Program, will provide an overview of marketplace appeals, detailing which decisions can be appealed, how to file an appeal, and ways to expedite the appeals process. And with that, I'll turn it over to Mara.
Great, thank you so much. And I'd like to thank the Center on Budget and Policy Priorities for inviting me to present and for all of you for joining us today. Let's get started. So just so you know, in terms of some upcoming webinars from Beyond the Basics, there's one on special enrollment periods in a couple of weeks. If you're not registered, you can see the link at the slide, on the slide, or I'm sure there'll be follow-up information sent out as well. Ina went through some of the webinar logistics, so I will skip that and go right to the National Health Law Program, or NHeLP. NHeLP is a national nonprofit organization. We're a little over 50 years old, and throughout our entire history, we focused on improving healthcare access and quality for low-income and underserved populations. We educate, we advocate, and we litigate, and please feel free to check us out on our website or to follow us on Twitter and Facebook. One note, as Ina noted, I'm the managing attorney of NHeLP's Washington, D.C. office, but I do want to be very clear that I am not providing direct legal advice, and neither is the National Health Law Program at this point. We're providing a general overview, and any questions that we answer are also not going to be specific to any individual cases, but we're happy to provide this as a resource as we go forward. So in terms of what we're going to cover today, there's going to be 5 main points that I'll go through. What types of determinations can be appealed, how individuals can request an appeal, the role of assisters, including navigators, certified application counselors, and others in the appeals process, what happens when someone files an appeal and if a decision is made in favor of the individual. And finally, we'll go real briefly through the No Surprises Act, which is a relatively new law, and an appeals process was launched this past January. We really want to make sure that people understand the differences between no surprises and marketplace appeals so that people can get the right help that they need at the right time. So let's dig right in. The first topic we're going to cover is what kinds of determinations can be appealed. And again, we're talking about marketplace eligibility appeals. So primarily what we're going to be addressing is what happens at the federally facilitated marketplace, or healthcare.gov. There are some opportunities where individuals who are enrolled through state-based marketplaces can appeal through the federal site. And we'll get into a little bit more detail on that. But primarily, if an individual is receiving coverage or applying through a state-based marketplace, their appeals process will start with that state-based marketplace, and only if they find a decision is not favorable to them do they have an opportunity to then utilize the federal appeals process. So just to be really clear, the folks who work on marketplace appeals are in a part of HHS that also covers Medicare appeals and sometimes will cover Medicaid and CHIP appeals. It's called the Federal Appeals Entity, or FAE, and we'll go through a little bit of the steps in the process as we go forward. So what's really important to note is that a consumer can appeal final decisions. If a consumer has a temporary or time-limited eligibility, or has a data matching inconsistency and has to provide additional information to healthcare.gov about their income or their immigration status, those interim decisions cannot be appealed. There's also a few exceptions that I include on this slide here, that even if one part of sort of an eligibility decision is final but another is not, that's still not going to give an individual the avenue to appeal altogether. So this first exception, let's say someone has applied for a special enrollment period based on a change in their circumstances, and they get denied the SAP. They can't appeal the denial of the SEP if they also have an unresolved inconsistency. They have to wait until that inconsistency is resolved. And the second, again, is if a person, sometimes individuals may actually have like 2 data matching inconsistencies. They may have to provide information about their income and their citizenship status. If they resolve one of them but other inconsistencies remain, the individual can't file an appeal until all of the inconsistencies are addressed or the expiration of that time period. All right, we're starting out a lot with what can't be appealed, but I think it's important not only to know when consumers can appeal, but when they can't. So again, a decision has to be final and appropriate. We don't want to waste consumers' times by filing appeals if they're just going to be told it's not ready and available for their process. It gums up the process for them. It also gums up the process, honestly, for others who have appealed. So again, the most important sort of first question is, has the individual received a final determination? And is it part of a subject matter that can actually be appealed to the marketplace? And sometimes it actually might even be better and more expeditious if a consumer, even if they have the right to appeal, looks for help another way. So sometimes individuals may want to expedite their case by calling the call center and try to get casework, someone to take a quick look at their case and investigate some of the pieces before going through a formal appeal. Sometimes they can appeal with their insurer, the State Department of Insurance, or again, file a complaint under the No Surprises Act. So what I'm going to go through in the next couple of slides, in which we've also outlined in an issue brief, which is on the Beyond the Basics website, are some of the different situations and what process a consumer should go through and what the potential results are. So let's start with casework. CMS is the Centers for Medicare and Medicaid Services. CMS oversees healthcare.gov as well as Medicare and Medicaid and CHIP. And as I mentioned, casework can often provide a quicker result if there's just a minor issue that someone is facing without having to go through a formal appeal. Sometimes an individual may have a complex eligibility or coverage issue that the call center can't help with or the insurer can't help with. Or sometimes there's an exceptional circumstances special enrollment period that needs a little bit more assistance. In these cases, if the consumer calls the call center and the call center cannot assist, the consumer can ask for casework assistance. And the casework folks who look at these cases are not part of the call center. They're more subject matter experts who have this direct policy knowledge, and they can look at a situation and sometimes assist more directly and move an eligibility determination through. So that's the first bucket that I think is really important for people to understand and know what the options are. The second bucket is there's a number of decisions that insurers make about coverage of particular services or prescription drugs, refills, reauthorization of services, things like that. In these cases, the insurer usually is the first line of requesting assistance. So for example, if a provider is listed as in-network, but then the provider says, well, they're not accepting the insurance. Or the consumer goes to the emergency room and the consumer's bill says the provider is out of network and payment is owed. These are two new situations that come up under the No Surprises Act in particular. But again, usually the first opportunity and the first step is for a consumer to go to their insurer and get assistance. The insurer is also the first line of assistance if the insurer denied a claim, would not cover a prescription, or canceled their coverage. And this bottom box here talks about what happens. The consumer can file, sometimes it's called a grievance, sometimes it's called a complaint, sometimes it's called an appeal. And the insurer has to respond within 180 days of receiving the initial decision. If the insurer still denies the claim or the service or the decision about having in-network versus out-of-network, there's often then an external appeal. And again, more information on the types of situations that should go to insurer appeals is available on healthcare.gov. Another option for consumers is to go through their State Department of Insurance. This can be the second step sometimes after an insurer has denied a claim. It could also be for fraudulent sale of health insurance and for other findings that are listed in this top box. Again, most of the time, the Department of Insurance is going to expect the consumer to have first reached out and attempted to resolve this directly with the insurer. But if that doesn't happen, then the State Department of Insurance may be able to step in. Some states have what's called an ombuds program, which can be within the Department of Insurance or sometimes separate that can offer assistance. But individuals should look at their State Department of Insurance website or the National Association of Insurance Commissioners to find the information for their Department of Insurance and get in touch with them to see if the consumer's situation is best resolved by the Department of Insurance. So the final bucket, and what we're going to spend most of our time on, are marketplace appeals. And again, these are decisions that are made by the marketplace, whether it's the federally facilitated marketplace at healthcare.gov or it's a state-based marketplace. And again, as you probably know, your state-based marketplaces can have a number of different names. So you might need to look into that and make sure and find out where you're getting coverage from. But the types of decisions that can be appealed include denial of tax credits, adjustment of tax credits if the individual has a data matching issue and is supposed to provide additional income information. Sometimes at the end of that period, if the marketplace doesn't think that information was sufficient, or if the consumer failed to provide additional information, the marketplace may actually adjust and potentially reduce someone's tax credits. And if that happens, that's an appealable decision. Other things as we see here, denial of eligibility, denial of a special enrollment period, termination of coverage, denial of coverage exemptions, denial of eligibility for Medicaid and CHIP. This one is only if, in case the FFM is determining Medicaid and eligibility. For some states, they've only given healthcare.gov permission to assess eligibility, and an assessment is not a final decision. The final decision is made by the state Medicaid agency. That wouldn't be appealable to healthcare.gov. That would go to the state Medicaid agency. So if a consumer disagrees, the consumer generally has 90 days within this final eligibility determination to file an appeal. Sometimes if there are special circumstances, for example, maybe the consumer had a serious health condition and wasn't able to respond in 90 days, they might be able to ask for some additional time, but generally an appeal must be started and filed within 90 days. Okay, so before I get into some pretty specific examples about what happens at the federally facilitated marketplace, let's just talk real briefly about what happens if you are in a state-based marketplace. And if you take a look at this box on the bottom here, these are the states that currently operate state-based marketplaces. So again, if an individual is applying to a state-based marketplace and is denied eligibility or denied a special enrollment period or denied tax credits, the first appeal is to the state-based marketplace. And then only if they get a decision from the state-based marketplace that they don't agree with, can that consumer then appeal sort of at a second level to the federal appeals entity. And again, this last sort of red X here at the bottom of my list, again, just reiterates this difference between assessment and determination states. Some states use healthcare.gov to actually determine someone's eligibility for Medicaid and CHIP, while others only use it to assess eligibility. And if a state is only doing the assessment, if someone looks like they're eligible for Medicaid and CHIP, healthcare.gov sends that information to the state Medicaid agency, but the state Medicaid agency makes the final determination. And so that wouldn't be appealable until the state makes its final determination, and then the individual would actually appeal that to the state Medicaid agency. So I know I've thrown a lot of information at you, and I think it's really helpful to go through some specific examples to see when certain issues may or may not be appealable. And that's what we're going to spend the next part of the presentation doing. So let's get into our first example here. So if we have an individual, we'll call her Susan. She's determined eligible for marketplace coverage with tax credits. Her daughter is assessed eligible for Medicaid, and Alana's, the daughter's application is sent to Medicaid for a final determination. So what can Susan appeal? Again, anything that is final, Susan can appeal. So effectively, she was denied Medicaid because she was found eligible for marketplace coverage. So if she still thinks she's eligible for Medicaid, she could appeal. She was given tax credits to help purchase her marketplace coverage. If she thinks the amount of the tax credits is wrong, she can appeal that as long as she didn't get an income inconsistency. What she can't appeal is the assessment that Alana is eligible for Medicaid, because as I said before, that's not a final decision. So she has to wait for her state's Medicaid agency to decide if Alana is eligible. If the state says yes, great, Alana's enrolled in Medicaid. If the state says no, then Susan could either appeal that decision with the state Medicaid agency, and then if they deny it, it could come back to the marketplace. So that's our first example. Here's our second one, and this gets a little bit into this temporary decisions, which are usually not appealable. Okay, so let's take John, who applies for coverage at healthcare.gov. He's found eligible for tax credits, and his eligibility notice says the decision is temporary, and he must provide proof of citizenship status due to a data matching issue or a DMI. So can he appeal the decision that he isn't eligible for cost sharing reductions? No, not until that DMI is resolved. He does have some other options though. He could first go back and reassess the income information he provided during his application. And if he realizes, oh, maybe I didn't put in something, a summer job or a little bit of extra income I got, maybe that's the problem. He can go back and check the information and make changes. And if he makes any changes, he'll get a new determination. And that may still say it's temporary, or it may actually say there's no longer an income issue and he can proceed. So those are our first two examples. I'm going to spend a little bit of time now on sort of, the procedures that are in place and how actually one goes about requesting an appeal and filing the right information. And again, this generally has to be done within 90 days of getting a final determination. So individuals can complete an online appeals form. They can complete a written appeals request form. They can either do it online, print it and mail it, or they can, just print it out, fill it out by hand and mail it. They also can just write a letter. They don't have to actually use the formal appeals form. And they can either mail it or fax it in. This is a separate place from where applications can go to. I'm not sure if anyone's actually still doing paper applications. Certainly that was more prevalent a while ago, but it is important that appeals get mailed to this specific address and use this fax number rather than sort of anything else you might find on healthcare.gov. So again, we talked about the fact that in the FFM states, you have 90 days to file an appeal, or if an appeal is actually dismissed, you have 30 days to then request that it was reopened. So 90 days is really the primary one at the FFM, but if you feel that it was dismissed and it was dismissed in error, you can request that that appeal be reopened. In state-based marketplaces, again, that first line of appeal is usually going to be at the state-based marketplace. Once the consumer gets a decision from the state-based marketplace, if they disagree with that decision, they have 30 days of getting that state appeals decision to request a second level appeal at the federal appeals entity. And again, as I noted a little bit earlier, if 90 days has passed, sometimes there'll be a good cause exception. I wouldn't expect this, to be run of the mill. There really has to be a valid reason why someone missed that 90 days. So it really is important to know these deadlines and make sure that consumers are aware of them and actually do comply with them as they move forward. One of the questions we often get is, okay, well, someone got tax credits and that really helped make the coverage affordable and they're going to appeal. Can their tax credits continue during the appeal? And the answer is absolutely yes, but the consumer has to actually request that. So again, it's really important, and there's I think it's a checkbox on the federal appeals form or if someone's just writing the letter, to really note that the consumer wants to have their tax credits continue during the entire appeal. Sometimes they'll get, this is most relevant when someone is granted a certain amount of tax credits, but maybe thinks that the amount should be higher, that they want that lower amount to continue for some length of time. If ultimately the decision is made that the consumer was eligible, let's say, for more tax credits, then those new tax credit amount will start when the appeal is implemented. It could go retroactively if the consumer requests it, or the consumer could say, well, I was able to buy my coverage during the appeal. I'll just reconcile at the end of the year when I file my federal tax forms, and I'll wait to have that all taken care of at the end. So there are only certain times when tax credits can continue during the appeal. And so they can't be continued again if there's a non-final determination or at the end of an inconsistency period if the inconsistency is not resolved. So again, I know this gets pretty complicated, and there's certain circumstances where it's yes and certain circumstances where it's no. And that's why it's really important to make sure that if you are advising consumers, you really know the ins and outs of this. And as I'll discuss a little bit later, a lot of times it's really important to make sure that consumers who are considering appeals understand that they might be able to get free legal assistance to represent themselves during appeals, because this really is about their legal rights, and we want to make sure their legal rights are protected. So after a consumer files an appeal, the first step is for the federal appeals entity to actually make sure it's a valid appeal. So again, going through what we've just talked about for the last few minutes, is it a situation where an appeal is viable? Is it a situation where there are no outstanding inconsistencies or temporary eligibility? If everything looks good, the appeal is acknowledged and the process begins. If it's determined invalid, then the consumer is going to get a notice explaining that. The consumer may want to fix the problem and refile the appeal, or they may need to wait a period of time until temporary eligibility or an inconsistency period is done. So on the bottom of this slide, I talk a little bit here about why might the appeals be invalid, and hopefully from what I've talked about you'll understand. So it could be temporary eligibility, it could be someone was assessed eligible for Medicaid but didn't receive a final determination from their state Medicaid agency. It could be a denial of a covered service, which the federal appeals entity can't address. It has to go to the insurer or the Department of Insurance. So again, I think the best thing that we can all do is really help educate consumers about their different options and where they can go to get help. Make sure they're going to the right places so that assistance isn't delayed or denied if people don't meet timeframes, and make sure they understand all of their rights that they have as they proceed through the appeals processes. So let's talk a little bit specifically about the role of assisters in the appeals process. Because we have some complicated terminology, and some of the terminology is used in more than one situation. So let's sort of talk about the term authorized representative, because we hear this in multiple contexts. Usually if you are, let's just say you're a navigator and you're calling the call center on behalf of a consumer, you need the consumer's permission to do this, obviously. And you're called a third-party representative. Usually you are not making decisions on behalf of the consumer. You're just communicating on behalf of the consumer, and the consumer makes the ultimate decisions. If you're actually an authorized representative for the consumer on the application, you actually stand in the place of the consumer and can make decisions for them. But I want to be clear that the authorized representative for the application is different than an authorized representative for an appeal. So even though it's called the same thing, authorized representative, or AR for short, in the appeals process, an authorized representative actually is serving as a legal representative for the consumer. And that person can present information and witnesses, and again, effectively stand in the shoes of the consumer. It's a pretty high degree level of responsibility. And it's important to understand these differences here whether you're looking at just assisting someone with an application or calling the call center versus actually representing them for an appeal. So in the terms of the different roles assisters can have, generally consumers are representing themselves through the appeals process and often without legal assistance. And navigators or certified application counselors or other assisters can certainly help consumers in that process. The question is whether you actually want to assume the role of an authorized representative. So you can help consumers by explaining the appeals process and their right to an appeal. You can talk to them about how to file an appeal and where to file an appeal. You can help get them their eligibility determination notice or appeal request forms and mailing addresses. You can help them, know what those deadlines are. And you can also help them get information about free or low-cost legal help in their area. All of those are things that you can do without being their authorized representative. What I really want to caution folks about is to not provide legal advice. Besides the fact that there's unauthorized, that there often are state requirements about who can and cannot provide legal advice, if you're really stepping into the role as an authorized representative and representing that person's legal rights are at stake. And if you don't know all of the issues that could come into play legally about why this consumer is filing their appeal and what arguments to make and what evidence to present, you really could result in an adverse decision to that consumer that leaves that consumer without assistance. So again, you can certainly assist a consumer. You could even be a witness for a consumer in their appeal. You could be on a call with hearing officers, but it's taking on the role of the authorized representative in appeals that really puts you in a different level of standing, and you want to be very careful about. So you're not, also from a funding perspective, if you are a federally funded navigator, you can't use navigator funds to act as an authorized representative. That really has to be done separately. So let's go through an example here, and then I'm going to stop for some questions before we get to the second half of the webinar. So let's say we've got Ashley, who was unable to resolve an application issue through casework and is appealing. David was a navigator who helped Ashley file the appeal, and the informal phone hearing is coming up in a couple weeks. Can David participate in this hearing on Ashley's behalf? Sure. David could be a witness, but if he's not a lawyer, he really probably should not be acting as her authorized representative. What David could do is actually inform Ashley about the potential availability of free legal assistance and help connect Ashley with a local legal aid organization who might be able to provide help. So at this point, I think we're going to take a couple of questions before going into the appeals process and how to implement appeals decisions.
Thank you so much, Mara. We don't have any questions at the moment, but as a reminder, if you'd like to ask a question, click on the Q&A icon at the bottom of your screen and type your question into the box. We'll pause once more at the end to take your questions. Back to you, Mara.
Alrighty, then we will keep on going. So let's move into what happens after you file an appeal and how does it continue from start to finish. So what the federal appeals entity does is to review the facts and evidence. The first step is a phone conversation with the consumer and the authorized representative if the consumer has one. These phone conversations actually happen with a contractor to the federal appeals entity. And once the phone conversation sort of comes to its end, the contractor is going to describe what they think the resolution should be. If the consumer is satisfied, great, a written decision is going to follow, unless maybe the consumer withdraws the appeal because the consumer realizes it wasn't something that was valid to appeal in the first place. If the consumer is unsatisfied, the consumer can then request a formal hearing. And in that case, this is sort of the second stage of the appeals process. The consumer will get at least 15 days notice prior to the hearing date. These are again conducted by telephone, but in this case, it will be a federal hearing officer employed by the federal appeals entity who will preside over the hearing. The second stage is what we call in legal terms a de novo review. It's a fresh start. It's all new. They're not going to go back and assume that what happened in the first phone call was accurate. They're not going to necessarily defer to the marketplace's determination. So consumers can present witnesses. Again, it could be an assister, it could be a family member or friend, it could be someone else who was helping them with the process of applying. The consumer also can look at the appeals record before and during the hearing. And it is important to note, again, that the consumer and witnesses are providing testimony under oath. There are some times in situations when an individual may need an expedited appeal, which means it's put on a fast track. These are allowed only in very limited circumstances. So the standard time frame must jeopardize the appellant's life, health, or ability to attain, maintain, or regain maximum function. If a consumer meets these requirements, they would need to note on their appeals form that they need an expedited time frame. If something happens after the consumer files the appeal, they can actually call the appeals contractor and ask to then have it noted. So it's not 100% necessary to only do it. You don't get one shot and you're out. But as soon as something happens after someone files an appeal that would lead to an expedited time frame, it would be important to contact the appeals contractor. And in these situations, the consumer must explain why. And then the federal appeals entity will determine either that it is okay to use that expedited time frame, or they're denying the expedited request and are going to use the standard time frames. So let's do an example to help explain this situation a bit more. So let's look at Diane's case, who had her tax credits terminated due to an income data matching issue that she wasn't able to resolve. So she wants to file an appeal, but because her APTCs were terminated, she would have to pay 100% of her premiums to maintain her coverage. And this, as it would be for many people, would be a financial hardship. Can she request an expedited appeal? Unfortunately, no. What I showed you on that last slide, financial hardship alone is not going to grant someone an expedited appeal. And can she continue to receive tax credits, what we call sort of aid paid pending or pending benefits during her appeal? Again, unfortunately, no, because expired inconsistencies are not considered to be redeterminations, and so continued tax credits during her appeal are not available. Now, as another alternative, in addition to filing an appeal, she could go back in, update her application, try to address the income issues that may have come up that she wasn't able to resolve, and see if she does get a new eligibility determination that doesn't have an inconsistency. That may get a quicker resolution than the appeals process, but she certainly can still file an appeal. She's just going to have to wait for the regular time periods. If we take a slightly different example, that let's say Diane has a chronic condition and needs monthly medication to maintain her current health status, would she get an expedited appeal in this case? Yes, because if she doesn't get her medication, her health may be at risk, so she can request an expedited appeal. And again, this is important because some appeals can take a period of time to wind through the process, especially because, again, we've talked about that there's, two steps. There's the informal telephone call, and then there's the more formal hearing with a hearing officer. So if we look back, it's sort of like that financial hardship. If she was to pay 100% of her premiums and that she wouldn't get this medication that really is important to maintain her health status, it's because of the health status that she has the eligibility to request an expedited appeal. So after we go through either the informal or the formal hearing, the federal hearing officer is going to make a decision based on the testimony, evidence, and the applicable legal rules. This decision is in writing, and it should be issued within 90 days or as soon as administratively feasible. So this is why you start seeing this process can take a while. First, a consumer has 90 days from getting the final decision to file an appeal. Then it takes time to have that first level hearing, then a second level hearing, and then 90 days after the second hearing, at least until a final appeals decision is made. And so again, that's why sometimes it's more efficient for individuals to use some of those other options like casework or looking back at their eligibility decision and updating information rather than waiting for the appeal. Now, the decision of the federal appeals entity after the second hearing is final and legally binding. But if an individual still feels it's wrong, that individual could bring a case in court and seek to overturn it. I will be honest, as long as we've been doing this, I haven't heard of any of these appeals going to court. Again, that's just an extra step and hurdle for many individuals, even if they feel they got a wrong decision. And the time, energy, and resources it takes are sometimes very challenging for individuals. Again, depending on the circumstances, sometimes they're able to get insurance through other programs, or they're able to, clarify some of the information that may have led to the need for an appeal in other ways and get insurance that way. Once a final decision is made by the federal appeals entity, then we move into implementation. So for the most part, decisions are implemented on a forward-looking or prospective basis. And the change is effective following regular effective dates. And I think I forgot to update this, but sometimes I think those effective dates have actually changed, that it's now pretty quickly that you can get prospective relief. There's also an option in some limited situations to request retroactive implementation. In these cases, like for example, if the individual is granted higher tax credits, they can ask for those higher tax credits to be applied retroactively, and the consumer might then get reimbursed by their health insurance or not have to owe premiums for a month or two while it catches up and things like that. Sometimes, even though a consumer does get a final decision, it takes a while to be implemented, and it takes a little bit of effort on behalf of the consumer or authorized representatives or other advocates to move things forward. Again, this is just, ongoing challenges that sometimes people are facing, and I want it to be upfront. But if an individual feels that their decision has not been implemented quickly, they should really get back in touch with the federal appeals entity and try to move things forward. So let's talk about an example where retroactive coverage might be available. If we take the case of May, who was denied APTCs or tax credits in January, she appealed and paid her full premium from January to June, and then she won her appeal. Can she get her tax credits retroactively paid back to January? Yes, she can. If she wants, she could have them, the insurer then paid for January to June. Likely in that case, they would just sort of say she doesn't owe anything for a good chunk of the next couple of months. Sometimes the insurer may issue a refund. The other option could be that if she chooses to just say she'll get them prospectively, she would just, when she reconciles and files her federal tax returns, she might end up with a refund at that point to make up for these months where she was paying 100% of her premium, but ultimately was found to be eligible for tax credits from the beginning. Now let's take the case of May actually didn't enroll in coverage during the appeal process. So she said that it was too costly for her to pay 100% of the premiums. Can she get retroactive? Well, she only has one option. She can't go back like 2 months. She would have to go all the way back to that appealed eligibility decision, and then she would have to pay her share of the premiums from January to June. So when would someone want to do this? Well, they might want to do this if they actually had significant medical bills between January and June. If they didn't incur significant medical bills, it might be more financially feasible for that person to just say, let's go with prospective coverage, start it in June, forego coverage from January to June, and then have it go forward and be able to get coverage in that situation. I'm going to do another example here with the family glitch. The family glitch is still in effect right now, but we are really hoping that come 2023, this won't be a problem anymore. There's currently a proposed rule from the Biden-Harris administration to eliminate this family glitch, but for now, we're still working with this policy, so I did want to make sure to include it because it's still the case through this year. So if we take Benita and her family, let's say Benita's husband has affordable insurance through work, but the cost to insure Benita and the children is just too expensive. And it's deemed, and the way the current rules work, if the coverage is affordable for the employee, the cost of coverage for dependents and family members isn't taken into consideration. When she applies to the marketplace, she's denied tax credits because of the family glitch. So can she appeal the denial? Yeah. It's a disagreement. It's a final eligibility determination. But because the federal rules say she's ineligible for tax credits, her determination is based on the law rather than an incorrect application of the eligibility rules. So she would really, even if she appealed, she would still not be able to get help or tax credits for this year. So again, there's a proposal right now to eliminate this. We really hope that will be in effect. If you want more information, we've actually put up a comment portal. So if you know individuals who've been impacted by the family glitch and want to weigh in as to why this rule is important to change, we can make sure to get those out. And if I can find that link quickly, I'll try to put it in the chat as well. Okay, so I want to go through some key points to remember on marketplace appeals before we move into a couple of slides on the No Surprises Act. So again, remember that consumers can submit an appeal online using mail or fax. They don't have to use the official form. They can just write a letter. The first avenue or first step in the appeals is an informal telephone conversation where the appeals contractor will hear information, look at evidence, and if that's resolved to the satisfaction of the consumer, great, over and done. If a consumer is not happy with that informal hearing, they can request a formal hearing, and that would take place with a federal appeals officer. And then a determination would happen within 90 days or is administratively feasible after that second hearing. Okay, so let's go into the No Surprises Act. No Surprises Act, or NSA, is a new law, and some of its provisions regarding appeals just went into effect in 2022. The goal of No Surprises is to protect people from surprise medical bills. And this mainly arises in two situations. So people with private insurance who go to the emergency room and get care provided by an out-of-network provider. Because it's an emergency, the No Surprises Act says you can't be billed more than your in-network cost-sharing amounts. The second is people with private insurance who get non-emergency care from an out-of-network provider at an in-network facility. So let's say you know that your local hospital is in your network, and so you go to them for care, but then all of a sudden you're getting billed by the hospitalist or the anesthesiologist who's out of network. No Surprises Act protects those situations too. If you go to an in-network facility, you can't be billed more than in-network amounts, even if you have some out-of-network providers at that facility. It's important that the explanation of benefits, which is often sent to consumers after receiving care, must include instructions for how to file an appeal. So again, the first step, and we sort of talked about this earlier when we were going through issues that can be appealed to the insurer, the first step is contact the insurance company to see if someone made a mistake. And if you're not happy with the initial help, you can file an appeal with your insurer. You can also contact the provider and ask them to correct the bill. Finally, if the insurer can't help and the provider refuses to correct the bill, individuals can file a complaint by calling the No Surprises Help Desk. The No Surprises Help Desk and appeals process is different from the marketplace appeals process. If someone ends up calling the No Surprises Help Desk and it's really a marketplace issue, they're supposed to be referred over to marketplace appeals. But again, it's more helpful if we can help direct consumers to the right places where they need. So whether it's the No Surprises Help Desk, the healthcare.gov appeals process, their state-based marketplace, their Department of Insurance, I realize there's a lot of pieces of this puzzle, and that's why we probably have so many people who've joined us today to learn about this process. So let me go through a few resources and then we will get to your questions. Here's a couple of phone numbers. And again, if people are low income and need to have legal representation, They can look for their local legal aid organization and request assistance that way. We also do have a couple of websites here. We have a fact sheet that we put together, which summarizes some of that information I went over earlier in the presentation, and a couple of websites from the marketplace that also outline, again, what is and isn't appealable and how consumers can file appeals and where to do that. So at that point, I'm going to wrap up the formal presentation and happy to start hearing some of the questions.
Awesome. Thank you, Mara. We did have a few questions come in. So let's start with what kinds of situations have you seen where there is an issue with the tax credit amount that can't be fixed through the application and would require an appeal?
Sure. This often happens if an individual might be self-employed. They might have an off and on employment history like seasonal work. It could even be because of COVID. They've been out of work a long time. Usually what happens is when someone files an application on healthcare.gov, behind the scenes, the system is going to ping the IRS and see what people's past income has been. And if there's a pretty big difference between what the past income is and what they put in currently on their application, that's why you might generate an income inconsistency. So, we've really tried to help consumers understand this and provide, full information. They can even write a letter to resolve their data inconsistency, explaining why the income might be so different from what was in the federal data sources, or recent circumstances as to why there was, a jump or a decrease. And that will usually help. But sometimes it does just get to the point where, it's a complicated situation. And that's why sometimes going through casework, or it may result in needing to file an appeal.
Thank you. And do you have a sense of which types of appeals are most common and which types are most successful?
That's a really good question. I haven't seen statistics recently about this. I should probably try to get a hold of them. I do think that a lot of this, and it ebbs and flows, and there's just different pieces of the puzzle that sometimes sort of raise their head. So for a while, we were hearing about a lot of appeals with regard to what we call failure to reconcile. So individuals, if they receive tax credits, they're required to then file a federal income tax form the following year and reconcile the advanced tax credits they get with what they actually should have gotten. And sometimes they get a refund, and sometimes they may, owe some money. And so when that person then comes in to renew their coverage, they are supposed to have done this reconciliation. And if they failed to do that, they get a flag on their file, and their tax credits aren't going to continue. During COVID, FTR, or failure to reconcile, was sort of put on hold. So that tended to create a lot of appeals. It also created appeals because early in the pandemic, when we had the IRS so backlogged, even if someone actually had filed their income taxes, the IRS may not have actually processed the return because of their staffing and resource issues. And so you'd had people get flagged even though they shouldn't have. So I think we have seen that had traditionally been a very high number of appeals. We've seen that go down because of the suspension. And I think also just we've seen some of the issues related to special enrollment periods reduce as well, particularly with the newer special enrollment period for low-income people, which lasts a longer period of time. So I think it ebbs and flows. It also just depends on the time of year. Certainly in the January to April or May situation where people are resolving inconsistencies, you may see more appeals about the inconsistency issues as opposed to failure to reconcile, which could happen at a different time of the year.
On the topic of appeal statistics, do you know if CMS provides summary statistics of the number of appeals submitted and the results of the submitted appeals?
Not that I have seen. We ask for them, and I will go back and check, but I don't recall seeing them. Have you? I don't. I just want to make sure I'm not out of step.
Oh, I have not, but you are the sales experts that don't existing. I believe you for sure. So
I will check to see if anything has been made public, and if so, we'll certainly get information out to folks.
Sounds great. And do you know if the informal resolution conferences can be recorded or if they're automatically recorded and transcribed?
I don't know the answer to that one, and I think some of it may depend a little bit on state law. I would not record it without acknowledging or asking if that is possible. That gets into a different level, and that's beyond my knowledge. So I apologize, I can't answer that one.
No worries, that's a very specific question. So let's see, the next question we have. Can a consumer appeal losing APTC because they didn't reconcile their APTC because they didn't file a tax return?
Right, so that's that failure to reconcile issue. If the individual was required to file their tax return and didn't, they can appeal, but their appeal won't be successful. Now, if the consumer says that there's a reason, if the consumer files their income tax return in the interim, let's say they file their appeal on May 1st, and before the hearing they file their income tax, so they're sort of fixing the situation, then they might be able to continue with the appeal, although I'd say it'd probably be quicker to just go back into healthcare.gov and update and say they actually did reconcile. But again, that's going to be one of those situations where you can file, but the result is not going to be in your favor if you really didn't reconcile and you're required to do so. So it's sort of like, it's not worth telling consumers to do it in that situation because the result is still going to be the same, which is they're ineligible for tax credits. You've just delayed the decision making for a period of time.
Switching gears a little bit, do you know if state-based marketplaces are supposed to be equipped to resolve issues with casework?
I think it probably depends on the state and also the level of call centers. I think some state-based marketplaces may have different levels of call center representatives, so they may just do it through their call center with a higher trained or higher tier of call center representatives, so it can sort of escalate from your primary call center rep to someone with more expertise around certain circumstances. I don't know specifically if states have sort of implemented something parallel to the casework system that healthcare.gov has used.
And one last,
you're all asking some real tough questions today.
well, thank you so much for your grace with some of the questions that are a little more complex. So we'll have one last question. Is casework the official name for the complex case process, or is casework separate from the complex case form assisters submit?
It should be the same. It's just whether you're going through an assister or whether you're going through the call center. So I think that there's been a lot of work to provide assisters additional ways to get that direct assistance. So either way, it's going to get to those same casework folks who can then process it. So if you submit a form as an assister, I would not then also go to the call center and do it. I would just try to follow up with the form and make sure that the necessary steps are taking place.
Great. Well, thank you again so much. So we can start wrapping up then. I will share again what Mara shared at the beginning. Our next webinar is scheduled for May 12th at 2 p.m. Eastern, 11 a.m. Pacific. We'll cover the ins and outs of special enrollment periods. We'll also focus on the new low-income special enrollment period. As a reminder, we'll be distributing the materials from today's session via email, and we'll post everything to the Beyond the Basics website. You can find additional resources on the website, including reference charts, guides, and FAQs. If you have questions or need assistance, please email us at beyondthebasics@cbpp.org. And with that, we will bring this webinar to a close. Thank you again for joining us today, everyone, and thank you, Mara, for this great presentation.